Very good morning to you. Welcome to today's webinar presentation, Estate Planning for Surviving Spouses, Considerations, Recommendations, and Procedures. Our presenter today is Stephen Elville, Managing Principal and Lead Attorney with Elville & Associates. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator for today. We appreciate those that are here for the first time today as part of our educational ongoing webinar series, and also to those that are frequent attendees. We encourage your general questions, so please note them in the questions panel on the right-hand portion of your screen, and we'll pause periodically throughout to address all your questions. Your questions add value, they help others learn, so don't be shy in posing your questions at any time. You also received the presentation slides by email yesterday morning from me to take notes on them if you wish, so please go ahead and do that. These materials are also available in the section marked handouts in the panel on your screen to download at this time if you wish. Everyone will also receive a post-webinar feedback email right after the presentation, so please take just a couple minutes to fill out this very brief survey to offer us your feedback about the presentation, and we always read and value every comment that you have to share with us. Here at Elville & Associates, we always want to be a resource to you for your families and your planning needs, whatever they may be. If you have new planning you need to address, old documents that may need to be reviewed, or perhaps another matter, consider a consultation with Steve here at the firm and use today's education as a jumping off point to get your planning started. Consultations are an ideal way to get your specific questions answered, have Steve understand your situation, and help create solutions and a path forward for you. So as we move forward here, I'd like to offer Steve and the firm a proper introduction before we get started, very briefly. We will jump into the presentation. So you should be able to see my screen here in the back. Elville & Associates, we were founded in 2010 here in Columbia by Managing Principal and Lead Attorney Steve Elville. We have several different practice areas and services that we focus on here at the firm on a daily basis, among others, estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Steve and I are coming to you live from the Columbia Gateway Community location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates, as many of you know. We do that in several ways through our planning processes with our clients. We offer many educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program, we're one of only 2 firms in Maryland to have an accredited client care program through the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. A little bit about Steve. His work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning. He's a member of many different national membership organizations, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, among many others. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve present before, offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for an 8th time in 2023 and a 7th consecutive year. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am very fortunate to be the executive director of. So if you'd like to learn how we work to make a musical difference in the lives of children each day, I would love to speak to you about it and share our story with you when we have just a bit more time. But today, we have other matters to address, such as estate planning for surviving spouses, an important topic in and of itself. So Steve, I'm going to go ahead and turn the presenter rights over to you. You should see that button pop up.
Thank you so much, Jeff. And
okay.
Really appreciate your introduction there. We have so much material to discuss this morning. Thank you for being so efficient. And I'm just going to get my screen up here and going and show our slideshow. And thank you, Jeff,
Hey,
again. I'd like to
that's
thank
good.
everybody. Good morning. Thank you, everybody, for being on this webinar this morning on a Wednesday morning. It's a very busy time of year. I know many of you have been on vacation or still getting ready to go on further vacations. I know the children are starting school or getting ready to next week in many places. It's just a great time of year. The weather is beautiful wherever you are. Here in Maryland, it's beautiful this morning. And again, we appreciate you being here. Jeff, thank you for all you do. And for all of those accolades, I could not accomplish anything without people like Jeff and the attorneys and staff here at Elville and Associates, and for people like you who support our webinar series and make it possible. So thank you. And along those lines, we have so much to cover today about an important topic, estate planning for surviving spouses. I have so much material. I want to apologize in advance. This is a very high level view of this subject. Couples, of course, this mainly applies to couples, but also for those of you who may be now a surviving spouse, I hope this will give some insight. So not only for couples that are looking to do estate planning or revise an existing estate plan, or to know where to head with an estate plan. For example, someone that doesn't really know enough information, doesn't have enough education to be able to move forward, or a surviving spouse that doesn't know what to do with their own planning or doesn't know what planning has been provided for them by their deceased spouse. All of these questions are very high level, very broad topics. So the bottom line here is we want to give you something substantive to walk away from today, to be able to use this in a substantive way going forward. We want to suggest that all estate plans should be updated, like Jeff mentioned. And I should say more specifically, all estate plans should be reviewed before possibly being updated, of course. And so our goal is to enhance opportunities for our clients and potential clients through education. And of course, we do the same thing here at Elville and Associates for all of our attorneys and employees. We're providing and looking for enhanced opportunities to make planning work the way it's supposed to. So thank you for being here. We're going to get right into the material. And as I advance my slide, obviously, we are meeting virtually here. We are not in an attorney-client relationship of any kind. So that kind of thing can be accomplished in an individual meeting, whether that meeting is virtual or in person. So just remember that this particular today's workshop, I should say, is not an attorney-client relationship, but we can have one of those if someone comes in, such as someone on this webinar this morning, to consult. And when we have a consultation, we are in an attorney-client relationship. But this is an educational program, and I want you to get as much out of it as possible. I also want to say that Jeff is a wonderful moderator, and he will take your questions if you have any. We do have a lot of material to discuss, but we will stop occasionally to try to take a question or two, and we will try to end on time where we have time for further questions. But also questions you may have after today, we are happy to try to answer those questions as best we can or meet with you in person. So getting into the material, we want to understand, why this is an important topic. Why is understanding how to plan for a spouse important? We are going to talk about how wills and trusts generally dispose of assets. We're going to talk about how the flow of assets goes between spouses and really understanding that in more than just a very fundamental way. We're going to talk about how planning for incapacity is very important as part of this process of planning for spouses. What is the planning perspective of the first spouse to die, as terrible as that may sound? What should that perspective be as we plan? What is the perspective if you are a surviving spouse as you're in the planning process or you're reviewing an existing plan? We're going to talk about income taxation issues, estate taxation issues, lots to talk about here, remarriage issues, and then we're going to come to a conclusion with the common trusts that are used in spousal planning today. And we're going to talk about actually making plans actually work. How do we make sure that plans work the way they're supposed to during life and after we die on the death of one or both spouses. And again, we're going to revisit this issue of reviewing older estate plans for married couples, and then we're going to take questions and answers. So that's an awful lot that we're going to review and go over. If you have a tablet or a piece of paper handy and a pen or pencil, your smartphone, whatever you have, I encourage you to make some notes as we plunge into the material here. All right, so let's get into this first piece of the presentation. How do we understand this, and why should we understand this as important? Well, estate planning is a partnership. It's a good faith agreement between spouses. And I know some of you on this webinar are spouses that have been together for a long time, and that's going to be relative to you. Some of you have not been married for a long time. Some of you may be on this webinar thinking of marriage. But estate planning is a partnership and basically good faith between spouses. The spousal agreement is essential because that's what makes planning work. Believe it or not, it's possible to be a surviving spouse, and due to the circumstances and due to really having not a lot of knowledge about the planning that was done, or not recalling what the planning was that was done, it's possible that because of forces that are at work after someone passes away, the first spouse to die, that the plan doesn't work as intended because maybe the survivor doesn't make that plan work. So in other words, this good faith agreement is not just legal, it's emotional and it's practical. There has to be an agreement between spouses that whatever is agreed upon will actually be carried out, and there will not be an attempt, whether it's intentional or unintentional, to change that plan that was agreed to. So we'll get into that a little bit more. And estates can be simple, estate planning can be simple, or it can be complex depending on what the goals are. And we're going to talk about that. Income taxation issues and estate taxation issues should be addressed in advance. So these are the reasons why this is so important. Future family harmony and future family support for the surviving spouse can be achieved through family harmony, of course, and through the proper planning and family education. Remarriage considerations need to be addressed, and how asset protection is going to be achieved if that is a goal. Remember that asset protection can be accomplished for spouses or other beneficiaries. In blended families, we have to address the issues of children from different marriages, assets of different marriages that were accumulated, and other issues related to blended families. And then other planning goals, things that may have to be agreed upon that have to do with different children, or children that have special needs or disabilities, or certain kinds of assets that were inherited, and perhaps there is a goal to dispose of those assets in a certain way. And then asset alignment issues. Remember that an estate plan, whether it's a will or a revocable trust, a basic estate planning, fundamental estate plan, those plans have to be properly funded or aligned. And we have to be transparent about that. We have to talk about what if there are long-term care issues in the future? How does that affect the agreement? How does that affect how the assets were funded? And what happens when things go sideways because there's a long-term care issue or other issues? So all of these things mean it's very important to plan if we're married, thinking about being married, or if we are now a survivor, to understand spousal planning. Now, let's talk about real fundamentals. What goes on in most wills or trusts? And I'm going to just break it down to the very basics. There's usually in my experience, about 4 major categories of disposing of assets: tangible property, furniture, belongings, jewelry, special collections, so forth. Specific gifts, these are gifts of cash or charitable gifts, or specific things that are going to be gifted that are not just ordinary personal property. Or there can be what I would call special provisions. These are provisions such as grandchildren's trusts, or maybe there's a family vacation home, and that's going to stay in the family down through the generations, or specific pieces of real estate that are gifted. That's kind of the second category if you want to think about it in simple terms. The residuary estate. Now, this is where the main focus is today for this webinar. When assets are flowing between spouses, the balance of the estate generally is going to be the residuary estate and how it goes between spouses. This is not 100% all of the time the case, but this is where we're going to focus today, is the residuary estate. And then the ultimate beneficiary. Where would the assets go if there was no surviving spouse, if there were no descendants, if there were no other beneficiaries living? Where would the estate go? All right, so how do assets flow to surviving spouses? Well, many of you are thinking about leaving assets outright, or many of you have already done this in your estate plans, whether they are will-based plans or whether they are revocable trust-based plans. You're leaving those assets outright with no marital control. If I die, I'm leaving assets to my surviving spouse outright and free of trust. And remember that this concept also applies to life insurance, IRAs and 401ks, or any other beneficiary designated asset. It can be straightforward, very simple, outright with no marital control. So that's very simple. Or assets can be left in trust. They can be left in a way where the deceased spouse has marital control, I will call it, and they can dictate for whether it's personal reasons or whether it's tax-driven reasons or asset protection-driven reasons. They can control those assets and how the survivor will benefit from those assets and how those assets will be held. Beneficiary designated assets such as life insurance can be driven in different directions, driven to the survivor, driven into a trust. IRAs can be driven to a survivor or driven into trust. And these are big issues in today's world due to the Secure Act and other issues that affect surviving spouses and how assets might be held in trust, if that was a good idea or not, is a counseling issue, and whether or not the client really understands the tax ramifications and other ramifications of such designs. So we want to just get our minds generally around how assets flow. We're going to have some diagrams here shortly. Let's switch now to the importance of incapacity planning. So remember, at our firm, Elville and Associates emphasizes planning during life and not just planning at death. So why do we think so much about this planning during life? Well, because people are living a long time, number one. The possibility of incapacity is very, very real. So we want to plan for that. But what happens is we're really designing flexibility. We're really understanding our self-determination. We really need to get our minds around supported decision-making and how that affects not only persons with disabilities, but people that are aging. We want to look at our design, whatever that may be, wills or trusts, but not just plan for death, but plan for life. So in the asset preservation and long-term care arena, the incapacity documents are paramount. They are a priority. Understanding government benefits and spousal rights. This is all part of, along with avoiding guardianship, this is all part of planning for incapacity. If we were to have a panel of estate planning attorneys across the United States, there probably would be a consensus that the financial powers of attorney are arguably the most important of all the documents. And why would that consensus be? Well, the consensus in that regard is because estate planning attorneys and elder law attorneys from this side of the table, we understand that without these documents, clients do not have the flexibility they need, not just for the incapacity planning itself, paying bills, taking care of the principal, who is you, the person who gives this power, but also taking care of spouses, taking care of anyone who is dependent on the principal at a time of disability. So this power of attorney allows for flexibility for estate tax planning, gifting, compensation of agents, being able to move assets in and out of trusts. Very, very important. But of course, the incapacity planning documents for healthcare are extremely important as well. This diagram shows a typical situation with regard to incapacity planning and the power of attorney documents, financial and health, that are really essential and should never be ignored, and they should always be updated. This brief slide is just an important reminder that even though I am focused this morning mainly on the financial side for many reasons throughout these documents that we're talking about, we don't want to forget about healthcare decision making, avoiding guardianship of your person, customizing the healthcare decision making as much as possible in the sense of really looking at the nuances of the advanced medical directive, and between spouses, understanding what each spouse wants, making sure that each spouse's desires and wishes are going to be carried forth, and understanding the MOLST form, MOLST and POST, which are in various states. Maryland calls this form the MOLST form, which is not an advanced directive, but is an extension of healthcare decision-making in Maryland. So we don't want to forget this important aspect of incapacity planning. Now, let's talk about the perspective of a first spouse to die from a conceptual point of view in estate planning. First of all, we always want to start with goals. What is the goal of any person who is doing estate planning, but in this context for a spouse? What is our goal? So is this a first marriage or a second marriage or a third marriage or more? What is the situation with regard to children, or are there no children? Because planning for spouses with a situation where there's no children is sometimes different in some ways than if there are children, biological or otherwise. Is marital control desired? So we're going to talk about this. What is marital control? Well, marital control could be emotional. It could be a need to or a desire to provide asset protection for the survivor. Or it could be we don't want that marital control. We want simplicity. So when we think about complexity, marital control, which is asset protection, remarriage protection, as we're going to talk about a little bit later, versus simplicity, what we really want to think hard about is, well, we might have a goal to be simple, to keep things simple. Nobody wants complexity just for the sake of complexity, but what is our definition of simplicity as juxtaposed against goals such as asset protection, remarriage protection, protecting assets down the line for children, grandchildren, or even a special needs child, and retirement plan asset considerations. So many people, many of you, are saving most of your assets, or larger portion of your assets are retirement type assets. And when you're driving those assets either to a surviving spouse or to a trust for a surviving spouse, or in some cases, you're driving those assets to others other than a surviving spouse, what does that mean? And how is marital control achieved if it is desired? And what are the ramifications of it? What are those complexities versus outright distribution? Now let's go back to outright distribution because it's one of the bullet points here. What does it really mean? Well, it's the most efficient. It's efficient for IRA purposes to leave to a surviving spouse. It's efficient for general purposes. So in a perfect world, we would all leave assets outright to a surviving spouse. But in the practical world, in the real world, surviving spouses can remarry. They can leave assets to a new spouse. They can disinherit children. And that's probably not going to happen in most cases, but it does happen. And of course, clients see, like potentially some of you on this webinar, see these issues happening in real life. So we have to be transparent. We have to be real about these issues and at least touch base with ourselves about how we feel about these things. And then knowing what our goals are, we can live with that, whether that is more complexity with more asset protection and spousal control or remarriage control versus simplicity. So when we think about asset protection, why do we think about that so much? Well, when we are spouses, when we have tenants by the entirety protection of real estate or of other assets that can be achieved through tenants by the entirety, we have to be aware that when one of us dies, we have no tenants by the entirety's protection anymore. So do we want to provide at least what I would call a modicum or minimum of asset protection for the survivor? And that can be achieved through trust planning. But we have to understand how those trusts work. Another point here, should a surviving, there be some kind of control mechanism? Do we want to protect the shares of children? So if one of our goals is to protect the shares of our children, well, not only when they receive it, because remember, a child can receive assets in trust or they can receive it outright, very similar to how a spouse can receive it. So if we're going to protect the child's share or the children's shares in further trust, does it make sense to protect the amounts that we're leaving to the survivor so that those amounts will eventually flow down? Whatever is not used by the survivor, those amounts will flow down to the further children. And as I mentioned a little bit earlier, does the surviving spouse get 100% or only part of the assets? And this has to do with spousal rights versus goals. All right, so let's get into the next slide now. We have a lot of material to cover. Now, the perspective from the surviving spouse might be, and usually is, will I have enough assets to live on? So, hey, what is this talk about not leaving everything to the surviving spouse? Well, in truth, most spouses leave everything to the survivor. So I'm only talking about a minority of cases where there is no 100% or not full 100% disposition to the surviving spouse. But the surviving spouse obviously is going to say, well, will I have enough assets to live on? What will my income be? Will my children try to control or take advantage of me? And in most cases, this is not going to be the case, but it does happen, and we have to think about this for the survivor. Will I understand how to deal with a continuing trust? So let's say that in the spousal planning, there are further trusts that are going to happen for a surviving spouse. Will that surviving spouse understand how to deal with this? And they should be educated and they should feel comfortable and they should be ready to understand this or to deal with it. They don't have to deal with it alone. They will be dealing with it usually with a team of advisors. Their advisory team, as we like to insist that people should have. Now, again, this whole issue of the surviving spouse, would they prefer simplicity and this outright distribution? But with that said, some spouses are in a high-risk profession. So if you are in a high-risk profession, even though you might prefer simplicity, from your lawyer's perspective, the lawyer may say, that's just not a good idea. If assets could be held in trust for you as a surviving spouse, and you're in a high-risk profession, you should welcome that sheltering of those assets, because assets that are left in further trust, and those trusts are properly drafted, those trusts are going to protect a survivor who is in a high-risk profession. They're going to protect that survivor from the claims of creditors. Is remarriage a possibility for the survivor? And we openly talk about that here at our firm. We talk about statistics and how many men remarry versus how many women remarry, and we try to laugh about this, and we try to get a good academic understanding of this because it is a reality. So if this remarriage is a possibility, even though most people do not intend to ever remarry, let's say, but if it's a possibility, we want to address that in a transparent way. And how do we protect children and other beneficiaries and the surviving spouse? Will the surviving spouse be the trustee of a trust left for their benefit? So one of the issues in spousal planning is not only will there be a trust for the survivor, but who will be the trustee of that trust? So a surviving spouse can be a trustee of a marital or non-marital trust. We're going to talk about that in a little while. But whether that is a good idea or whether that's desired is really a planning discussion. It's a planning discussion having to do with goals. Will the survivor understand how to make post-mortem tax elections? Well, there are certain tax elections that should be considered and sometimes must be made on the death of one spouse. And the survivor usually will be the person to do that. So will they understand that? And will they have the professional resources they need? We need to give surviving spouses the assurance through education, through the implementation of an advisory team, that they will have the benefit of the resources they need to make these decisions. Now, income taxation issues, we're just going to touch briefly on this. But as this discussion is so broad, and if you engage in this further discussion in a consultation or in a series of meetings for your own updated estate planning, we're going to be talking with couples about the use of the unlimited marital deduction. So Uncle Sam provides couples with an advantage to be able to leave assets to each other in certain ways that are advantageous for income tax planning and estate tax planning. So that is something that is a very fundamental thing that should be understood. Cost basis adjustments at death, which we call the step up in basis. Trust taxation. Let's say we leave a trust for a survivor, or we leave trusts for further beneficiaries. We want to understand the trust taxation of those vehicles, because those vehicles have to have their own tax ID number, okay, and they have to have maintenance. And this gets to the price of marital protection. The price of marital protection really is the price, when I say it that way, the cost of it is it's going to have some increased costs. There are going to be tax returns that are due. There has to be a certain series of tax elections after the death of one person. And this is going to increase the overall cost of planning. So protection does come at a cost, and that cost needs to be understood. Understanding non-marital trust planning, meaning leaving assets in a way other than the marital deduction, which I will illustrate here in just a little while, that is something that needs to be basically understood in the planning process. Understanding the difference between grantor trusts and non-grantor trusts. This is something that you don't have to have a in-depth understanding of, but you at least need to have a surface understanding. So for example, a revocable living trust, which is a substitute for a will, it's not a mysterious thing, that is a grantor trust. That is a trust that the grantor pays their own income tax, just like they always did. So the trust is not a separate entity for taxation. But a non-grantor trust, such as a marital or non-marital trust, or a further trust for beneficiaries under a will or trust, that is a non-grantor trust, and those trusts pay their own taxes. So how to deal with those trusts is really part of education, which is what we do here at Elville Associates. Retirement plan assets, we've talked about this a little bit. They have their own characteristics. They have their own taxation genre, and this is affected now by the Secure Act, which affects a lot of people's planning. So most estate plans need to be reviewed, if for no other reason than for the Secure Act. But understanding how these retirement assets flow from person to person, or from a person to a trust for the benefit of another person, is very important. Life insurance, which is not income taxable, but is estate taxable. These types of issues have to be understood. Life insurance planning for a surviving spouse, and we're going to talk about that in just a few moments. Jeff, I'm going to stop just to see if we have any questions so far, and just to take a sip of water. We've been going pretty hard now for about 30 minutes.
I appreciate it, Steve. I was going to stop you after the next slide. So you're reading my mind. Just a couple of questions here regarding the deceased spouse's Social Security benefits. What happens to them?
Thank you for that question. Well, it's going to depend on a lot of issues. It's going to depend on whether there is a surviving spouse and whether that surviving spouse's Social Security benefit was greater or lesser than the deceased spouse. It's going to depend on whether there were any disabled children. So that's going to be a case-by-case issue. But the deceased spouse's Social Security amount for themselves obviously stops, but it may continue in a certain manner for spouses or children, depending on that status and situation.
Okay, next question is, what does it mean to fund irrevocable living trust?
Thank you for that question. There are two major aspects of a revocable living trust, if we want to break it down to the very basics. One is creating the trust itself, being happy with its terms and provisions, and understanding them, in my opinion. The second phase is the funding phase. And if we want to think about that a little bit differently, we might call that asset alignment. So the revocable trust is a nice structure. It's a nice document. It's a nice estate plan, but it won't work for us unless we align our assets with the trust. So the basic answer is we have to take our non-retirement assets and we have to put them inside of that trust. We have to retitle them, or we have to drive them there someday after our death by some kind of beneficiary designation, like a transferable on death designation. And one way or the other, that revocable trust has to flow down our non-retirement assets. Retirement assets do not get put into that revocable trust, although retirement assets can be driven in different ways after the death of the plan participant. So asset alignment or funding is making sure that a revocable trust has control of the assets that it's supposed to control so that it can flow down those assets to beneficiaries.
Okay, and then a question that is probably alluding to something on the next slide from our good client, Mr. Smith. Does Maryland inheritance tax also not apply to per stirpes? A question on the
Well,
next slide.
thank you for that question. And I think that I understand where that question is going. Maryland inheritance tax was abolished except for non-lineal descendants, to give a very general answer. So if I understand the question directly, partially at least, the Maryland inheritance tax would not apply to descendants and further descendants of a descendant through a per stirpes distribution.
Okay, thank you, Steve.
Thank you, Jeff. All right, and thank you for those wonderful questions that make the webinar better for everybody. Let's talk about estate taxation briefly. So the current state exemption amount for Maryland is $5 million, which is the highest I have ever seen it. The federal exemption is $12,920,000 and will be adjusted again for inflation coming up. But in 2026, those are slated, or at least the federal exemption is slated to drop. So we're going to see politically and otherwise whether that is going to happen. But we have to understand gifting and how that affects taxation. So there are certain exclusions that Uncle Sam allows. Currently, it's $17,000 per person per year. I'm switching to gift tax now. That's what we're talking about. So you can give $17,000 per year per person to as many people as you want. And that is the annual exclusion from gift tax. However, if we don't go above that 17,000, then Uncle Sam doesn't count that. But if we go beyond the 17,000, Uncle Sam starts to count and counts these additional amounts against our $12,920,000 exemption. So if we go above the 17,000, we have to be aware that we're using some of our $12 million exemption. But most people are not concerned about this in the general sense. The middle of the road person who does not have $12,900,000. However, there are people who do, and they have to potentially think about using those exemption amounts now, as I'm skipping down to one of the other bullet points. So if you are a person who has assets exceeding these amounts, then we have to maybe think about potentially using those amounts now through large gifting strategies before those amounts may go away in 2026. But going back up to the prior bullet points, these types of considerations affect the tax elections that have to be made after the death of one person. So if you're married, you're a couple, you're going to be looking at, depending on the type of estate plan you're doing, making certain elections like the qualified terminal interest property election, the QTIP election, or the portability election, allowing the survivor of you to utilize the exemption of the deceased spouse. And it's beyond the scope of today's discussion, but this is a huge simplification of the estate tax planning for most people that several years ago this was started. And it's something that the survivor review wants to consider, and in many, many cases, actually make the portability election. So Maryland estate tax issues, we talked about the $5 million exemption. My personal belief is that the federal exemption, if it goes down, the Maryland exemption will go down as well, but that is not something that we can predict right now. Maryland inheritance tax, we just talked about that a moment ago. It's not applicable to spouses. It's not applicable to lineal descendants. Non-citizen spouses, those of you who are married to a non-citizen spouse or are a non-citizen spouse, we have to plan for the non-citizen spouse in a certain way so that we make the available exemption amounts available to them that could be made available to them, because Uncle Sam is very cautious about a non-citizen spouse surviving and then taking assets and moving back to their home country, and the United States government not being able to tax properly for estate tax purposes. So non-citizen spouses have certain special issues that we have to address. So the remarriage issue is really whether to control assets or not. Do we want to control the assets of a surviving spouse so that they have use and benefit of that property, but at their death, it flows down to the beneficiaries that we want the assets to flow down to? And also protecting against assets going to a new spouse. So this gets into the discussion of whether we use a marital or non-marital trust strategy. It also talks about or addresses the issue of, again, we talked about this earlier, who should be the trustee of the marital trust or the non-marital trust. I'm going to skip the spousal elective share law just for a second. This is also going to depend on prenuptial or postnuptial agreements. The surviving spouse, if they are a trustee, they have a fiduciary responsibility. And this gets down to the last bullet point, and then I'm going to come back to the elective share. This is what I was mentioning very early in the presentation, that the surviving spouse, if they are a trustee, they're a fiduciary, they have a responsibility to establish these post-mortem trusts intended by the deceased spouse. We don't see this every day, but we see it fairly often, where through the influence of relatives or financial advisors who may not be fully aware of what they may be encouraging, we see a surviving spouse that does not take the steps to establish the post-mortem protective trust that was implemented in the planning by the first spouse to die. So we want to honor and to protect our fiduciary duty as well, but protect the interests of the deceased spouse by making sure post-mortem trusts are established if they were intended to be established by the deceased spouse. Going back to the new spousal elective share law, in October of 2020, Maryland issued a new law, or implemented a new law, that protects surviving spouses. Now, this protection is so robust that it literally goes from spouses having very little protections to very massive protections for survivors. Now, this doesn't really apply to most couples who are traditional. They leave everything to a surviving spouse. But the ramifications of this are that the new spousal elective share means that a surviving spouse is able to elect against almost all of the assets of the deceased spouse. So if the deceased spouse were to not leave the survivor with at least a minimum amount, the survivor would have the ability to make this election. So what does this have to do with remarriage? Well, those of you who may have heard me talk about this before, here's where I'm going to reemphasize this again. If you are interested in protecting from remarriage and protecting assets and protecting children and grandchildren and nieces and nephews and the flow of assets down to them, you need to understand that if you ever get remarried in the future, if you're a spouse now, you ever get remarried, you should get a prenuptial agreement, because the prenuptial agreement or postnuptial agreement, but let's talk about prenuptial agreements, will protect against the new spouse being able to make an elective share claim against your estate. Here's where I'm going with that, and we're going to move on. Let's pretend that you said, I'm never going to remarry, but you did. Just through life and the circumstances that occur, you remarry. You remarry, and now where would you leave your assets? Well, I'm not saying you wouldn't leave your surviving spouse with any assets, but chances are you might leave most of your assets to your children, the children of your own marriage, prior marriage, before you entered into the new marriage. Now, that's not always the case, but let's just pretend that that was the case. Now, if you die and leave everything to your children, or most of your assets to your children, your new spouse has the right to elect against your estate, and that may thwart your estate plan. So you need to be aware that if you ever remarry, getting a prenuptial agreement might be an essential thing to make sure that your estate plan cannot be changed or thwarted in some way. So these are the remarriage issues that need to be considered. When we look at this diagram, we start to see that if we could kind of see ourselves right in the middle of this, if you can imagine that you are right in the middle of this slide, if you were to pass and you're married, you're either going to leave your assets in estate planning parlance. You're either going to leave your assets to the marital share. So those of you who might say, well, I'm keeping everything simple, I'm leaving everything to my surviving spouse in a very simple way. This is kind of in very simple terms, you're leaving everything by marital share to the survivor by way of the unlimited marital deduction. But you could also have a marital trust for the survivor. And there are certain income tax advantages, for example, or ways of thinking that we might think that for most people, leaving assets by way of the marital share, whether it's outright or in trust, is the most advantageous to do. However, there are also several other legal strategies or schools of thought about leaving assets to the non-marital share. This could be done by formula. It could be done in other ways. So conceptually, I want you to see yourself, if you're married, right in the middle of this slide, and we can either leave assets to the marital share or non-marital share on the first of us to die. And this slide here better illustrates that. This is your will or your fundamental documents here, your will or revocable living trust. And for a spousal couple, we're either leaving assets to the marital share, to a marital trust, or to a non-marital share or non-marital trust. So this is just very fundamental just to get your mind around this today. All right, now in the last 40 to 45 minutes, we've covered a lot of technical things. We've really talked at a high level, and I've tried to give you some bullet points that I think are trigger events or trigger thoughts to think about spousal planning in review or in new design of a plan. Let's look at some common trusts that are used in estate planning that have to do with spouses, okay? So irrevocable spendthrift trusts at death. Now that's a mouthful. Irrevocable spendthrift trust. Well, if we go backwards, and Jeff, I'm just going to go backwards for just a minute. When we look at a trust like a marital trust, remember we could have left assets to our surviving spouse outright, or we could have left assets in a marital trust. Well, a marital trust is an irrevocable trust. It is usually protected by a spendthrift clause, which means the beneficiary cannot give away assets to creditors or assign the assets to creditors, and that means there's asset protection in simple terms. So when we talk about a spendthrift irrevocable trust, that is a good example. That's an irrevocable trust at death created by the death of the first spouse to die, and that survivor is going to have asset protection in that trust if it's properly designed. Life insurance trusts. So life insurance trusts are used for various reasons, but what is a life insurance trust? It's an irrevocable trust. The life insurance policy is owned by the trust, and the beneficiary of the life insurance is the trust. And when this happens under various circumstances, the previous owner of the life insurance, or the person that is the insured, this life insurance, its face value, is not going to be considered in the estate of the person. It is removed from the estate of the person that is the insured, or the person that is the grantor of this trust. And many spouses are the trustees of these trusts. So the one spouse creates the trust, the other spouse is the trustee, but not always. But this is a common example. And whatever insurance is in this trust, whatever that value is, it is excluded from estate tax. So we don't want to pay 40% estate tax on this insurance money. We want to make sure this insurance money is used for its intended purposes. So after the death of the insured, this trust continues for the benefit of the surviving spouse, usually in many cases, and for children. And it's a very powerful tool because the life insurance can continue to be excluded from estate tax forever, and yet still be for the benefit of the survivor and for children. A spousal lifetime access trust is a modern term of art. And if I could try to give you a visual of this, I want you to imagine that this is a very sophisticated non-marital trust. So I'm going to go backwards again, and I'm going to illustrate this non-marital trust. And why would someone use a non-marital trust, let's say in a very simple plan like a revocable plan, trust or will? Well, perhaps there would be estate tax advantages for certain people that have very high net worth, or there could be more marital control. We could argue that there is more marital control if we use a non-marital trust. So a non-marital trust, a modern term of art, is that this would be what we call a bypass trust. And some of you are familiar with that terminology and some of you aren't. Well, a spousal lifetime access trust is a lifetime bypass trust. It is a lifetime non-marital trust. So someone with a large portfolio of assets could transfer large amounts, for example, 12 million, the current exemption amount of 12,920,000, could transfer that to a spousal lifetime access trust, and by doing so, make a gift to their spouse and their children and utilize their $12 million exemption during their lifetime. So in other words, they can use the exemption during their lifetime. The other spouse, if they're wealthy enough, can also do the same thing. This is a very popular tool, and this can be basically what we call a dynasty trust that has a lot of asset protection. Special needs trusts for spouses, Medicaid trusts, marital trusts, and bypass trusts, we just spoke about this, and lifetime marital trusts. So a lifetime Q-tip trust is similar to a lifetime spousal lifetime access trust, meaning it's a bypass trust versus a marital Q-tip trust. Let's get into the details just a little bit more on these trusts. So I mentioned this earlier, the irrevocable spendthrift trust at death. This can be for spouses or children or others. It can be under a will, revocable trust, or an irrevocable trust. And I mentioned that the marital trust or the bypass trust is a spendthrift trust at death. This provides control or protection or remarriage protection, whatever the goals are. And this is a non-grantor trust, meaning the trust pays its own taxes. We have to manage the taxation of the trust. There are lifetime gifting trusts, I like to call them. These are trusts where someone can establish a trust for a spouse, a grandchild, or children. And these are trusts that are very, very easy to establish. They are control mechanisms where someone wants to make gifts and they want those gifts to be controlled or protected from the claims of creditors. We talked about a lifetime Q-tip trust. So let's say that there's a couple, they want to achieve some significant asset protection. One spouse might have more assets than the other, and these are going to have to be non-retirement assets. These are not IRAs. And so there is a possibility of, well, we're not waiting until death. We are going to fund a marital trust during lifetime. And this is a very underutilized technique, but provides very powerful asset protection in Maryland for the right situation. And even though Maryland is not one of the quote, asset protection states, this is still a very powerful technique, a lifetime Q-tip trust. Of course, grandchildren's trusts, education trusts, these can be established either during lifetime or at your death. A charitable trust. All of these types of trust, the dynasty trust that I just mentioned, the SLAT, the spousal lifetime access trust, or leaving further trusts for children and grandchildren forever in perpetuity. So these trusts are either going to be grantor trusts or non-grantor trusts, depending on what the purpose is and what the trust is. So these are some of the trusts that you can get familiar with that have to do with surviving spouses. We talked about the life insurance trust. For those of you who are more interested in this, this removes the value of the life insurance from the estate of the grantor and the surviving spouse. It provides for control. It provides for asset protection. It could be that the life insurance is used for estate tax in the future. It could be that the Secure Act is going to cause huge income taxation on an accelerated basis on large retirement assets. And it could be that life insurance and a life insurance trust is a tool to accomplish wealth transfer because of the ramifications of the Secure Act. And many, many times the life insurance trust is created as a grantor trust for income tax purposes. So it is out of the estate of the grantor, but it is also a grantor trust for income tax purposes, which is very advantageous. We talked about the spousal lifetime access trust. This is the popular tool for wealthy individuals or couples to get assets out of their name and, so to speak, use their exemption amounts during their lifetime. The downside is, because it is a non-marital bypass trust that's created during life, there is a loss of the step up in basis. So there's a trade-off that there's going to be income taxation in the future if those assets are sold, versus the avoidance of estate tax, which is the avoidance of the 40% estate tax, which is obviously a greater advantage than just avoiding income tax, which is a lower rate. And depending on the jurisdiction, there are different advantages that can be added into this trust. So this is a very popular planning tool for certain couples. Medicaid and Veterans Trust. Now we're switching gears to elder care planning. So these are popular tools. These are creations of the elder law bar across the United States. Elville Associates is very fortunate that we are considered one of the subject matter experts in this area in Maryland. But the Medicaid Asset Protection Trust, for example, is a very powerful, flexible tool. So it's very popular. It's a control mechanism to be able to divest assets for long-term care asset protection, but still avoid a loss of the step up in basis at death, which is very important. We want the step up in basis. We want the gifted assets to the Medicaid trust or the Veterans Trust to be able to be exempt from the claims of beneficiary creditors. We don't want to take our assets, move them into a protected status for, hopefully for long-term care, but have the creditors of a beneficiary child be able to get the assets. We don't want that. So it's protecting those assets from the claims of beneficiary creditors. The way this trust is designed, and it's been pretty much proven throughout the United States, with the exception of a few states, this has been proven where the grantors can have some limited control and yet still get the assets protected for Medicaid purposes. So these are treated as grantor or non-grantor trust, depending on what the goal is and what kind of trust is being used. We talked about the marital Q-tip trust, so I'm not going to go back into that too much. This is usually where one spouse is wealthier than the other, and there's a desire to create control and asset protection during life for the spouse and children without having to go to an asset protection state such as Delaware or Nevada or Alaska or South Dakota or Wyoming. These are very powerful tools in Maryland when it's properly used and appropriate. The bypass trust. We've talked about a very high-level bypass trust, the spousal lifetime access trust, but let's come back down now to more fundamentals. Let's say that there is a desire to increase spousal protection or remarriage control. A use of a non-marital trust instead of a marital trust could be a proper tool. However, remember that we get one step up in basis at the death of one spouse, but we get no second step up in basis. So there's a big trade-off on the income tax side potentially to use a non-marital bypass trust. But there is considered generally more spousal remarriage protection in use of a bypass trust. But you'd have to give up the second step up in basis at the death of the second spouse. And that is a big consideration unless this is really needed. And sometimes these non-marital trusts are needed for wealthier couples, depending on what the goal is, versus leaving everything by way of the marital share. So this is a counseling issue. Using special needs trusts for spouses. Now, this is a state-specific thing, but it affects spousal planning. So those of you who are married, just know this, that since 1993, it is possible that if your spouse is diminished, has a diminished capacity, God forbid they have Parkinson's or Alzheimer's disease, they are not well, there's a chronic illness, it is possible to use a plan where there would be a trust created under a will. So let's say you're a well spouse. Well, many well spouses in these situations, they ask this question: what can I do? What can I do to be proactive? Well, the good news is that you can be proactive, and you can, if all assets were moved to your name. So let's say that many assets are moved out of the name of the ill spouse. This is not always going to happen, but let's just use for purposes of today's example, we move many assets out of the name of the ill spouse, into the name of the well spouse. Now, what are we protecting against? We're protecting against what if the well spouse were to die first? Well, federal law and state law now carves out an exception that says if the well spouse were to die first, which unfortunately does happen sometimes, usually doesn't, but if the well spouse dies first, he or she can protect the survivor in a special needs trust under a will. It has to be a special needs trust under a trust, under a will, and those assets that flow down into that trust are not considered to be available resources to the survivor, meaning that those assets can be used for the survivor's benefit, but the survivor can qualify for public benefits such as Medicaid and long-term skilled nursing, and these assets would not be available for spend down. So this is a lifetime management tool for some couples that as they get older are dealing with some kind of diminished capacity or illness. Irrevocable trusts can use what is called the crummy power. And so I just want you to know what this is if you're not aware of it. So let's take a life insurance trust as an example. So there was a man, I'll try to make you laugh. There was a man in the 1960s named Mr. Crummy. He had lots of children and grandchildren. I am not making this up. And he challenged the IRS and he said, you know, even though the annual exclusion back then was much smaller in the 1960s, he said, if I were to have a trust and I were to contribute money to this trust, okay, and I contribute the annual exclusion amount for all of my children and grandchildren, if I contribute, let's say, whatever that amount was back then, $5,000, whatever it was, and I multiply that times 16 because I have 16 children and grandchildren. And I honestly can't remember how many children or grandchildren Mr. Crummy had, but the concept is he was arguing if I contribute whatever that amount was, $4,000 or $5,000 times 16 into this trust, if I contribute that, that should qualify for the annual exclusion from gift tax. So the IRS challenged this, and basically Mr. Crummy won. And the IRS agreed that as long as the persons that you're gifting that to, as long as they have a present right of withdrawal, as long as they have the power to reach in there and get that money, then we will say, yes, you can use your annual exclusion. So a real fundamental understanding of the crummy power is what I'm trying to give you here. And you can now gift $17,000 per person per year into a life insurance trust, for example, an irrevocable trust like a life insurance trust, and that money is used to pay the premiums. But let's say that you wanted to get much more money in there and you had 5 or 7 grandchildren or children, you can put 5 to 7 times $17,000 into that trust, for example, and the premium might be less. The premium gets paid, but the excess amount stays in the trust, and you're able to get that out of your estate, and you're able to do that by using the annual exclusion. So that is called the crummy power, and the beneficiaries have to be notified, and they have to agree to not take those monies. Now, we can't overtly tell them not to take it, but they have to kind of pass on their right of withdrawal and let it lapse. And when they do, that is going to allow you to put that annual exclusion gift into the trust without having to pay gift tax or to be considered a taxable gift. So we want to make plans work. And I've mentioned this 3 times now because even though I don't want to focus on the negative, I have seen this happen, and I have seen this happen, and it always disturbs me when it does happen. So we want to make sure assets are funded into the trust, that they're properly aligned. This is a key. This is a really key issue. We don't want to use transferable on death. Let's say that we have a revocable trust. It's a wonderful trust, but your assets are outside the trust, and your assets are transferable on death, TOD, straight down to beneficiaries. Well, if you provided for control of assets for the surviving spouse or control of the assets after the death of the surviving spouse, but all the assets went straight this way to a beneficiary or went straight to the spouse, the problem is that the deceased spouse's plan did not work possibly. So we just want to make sure that we're reading the documents, that all of the advisory team members, including the financial advisors, are looking at the documents and making sure they're working with surviving spouses. Sometimes I believe financial advisors believing they're doing the right thing, are trying to make the surviving spouse's life easier, trying to get things done quickly, but sometimes it can be done so quickly that the intentions of the first spouse to die are thwarted in the sense that things are not structured or set up the way they're supposed to in the post-mortem period. And this is important. That's why I'm mentioning it a second or third time. So we want to consider current goals. All estate planning is goal-driven. If you don't know what your goals are, in a counseling session, one of the things we consider most important is to give you the time to think and to develop these goals if you don't already know what they are. Hopefully this material today will allow you to think through some of these issues as spouses and decide simplicity versus not so much simplicity, depending on what the goals are. Evaluate the structure of older plans. So we need to look at the marital and non-marital structure of older plans. Some of you may not even realize that you have these older plan structures in there that might have been used 15 years ago, 20 years ago, 9 years ago. But we want to look at those things because sometimes when the planning is done, it's done based on current circumstances. It could be time to simplify. We want to look at income and estate tax considerations in light of the new laws, in light of 2026 and the sunset of the estate tax exemptions. We want to look at the Secure Act. We want to look at trustee selection. This is one of the most important issues today, trustee selection. Revisit trustee selection. Add flexibility through trust protectors. Trust protectors have been in the law in Maryland, trust advisors, some people call them, since 2014. These are special fiduciaries that bring flexibility to documents, and then spouses should be looking at long-term care asset protection considerations depending on the size of the assets and what your goals are. So it's not enough just to educate. We've found here at Elville and Associates, we want to give clients and potential clients a chance to move forward, a chance to have a path forward. So we encourage you to contact Jeff or my assistant Barbara or my assistant Jasmine to get an estate planning questionnaire. let us see what is happening with you so that we can advise you. We want you to know there's nothing to fear. We want you to relax, because when you are consulting with an attorney in Maryland, even if you don't move forward as a client and you're sharing information, there's an attorney-client relationship. There's an attorney-client privilege, and everything is confidential. We want to see your current documents, as I just mentioned. We think that all plans should be reviewed periodically. We want to help you have an advisory team and work with your team collaboratively. If you don't have an advisory team, you don't have a CPA or financial advisor, we want to help you, or an insurance professional, we want to help you have that team. And then we want to make sure that team is actually talking to one another. We want to make sure they're really collaborative on your behalf. We love your questions. We thank you for the questions that you've asked today and that you may ask in a few minutes. But our goal is to really look at those questions when you come in and make sure we're giving you, what you're looking for, which is support and contemporary information. And lastly, we want to give you the time to think, because we know it's a busy world there. If we can create a space, and we have many conference rooms here at Elville and Associates, if we can create a space for you to think, we know that you'll be able to come to conclusions based on counseling, based on education, as to what the right path is and what your goals are. So thank you for sitting through that very dense information this morning, for spending your time with us on a Wednesday morning. We're hoping you're having a good week, and we appreciate you being here. Jeff, I'm going to turn it back to you.
Well, thank you, Steve. Really outstanding presentation. Lots of substantive information and takeaways for our attendees today. So thank you for your time and your effort with us today. So now would be your time to get those final questions into Steve. Steve, we have a couple for now, and I'm sure we'll get a couple more here. We'll go ahead and jump right in. Steve, what is your expectation for the federal estate tax exemption amount in 2026 when it drops? I know you alluded to that briefly. Do you have any additional thoughts?
Thank you for that. My thoughts are based on maybe some collaborative discussions with colleagues in other states. And one person who has a national practice that I spoke to recently, who's in one of the asset protection states, he believes that there's a very real possibility the exemptions will come down based on the slated drop. And he mentioned that the $5.5 million slated drop, which would be adjusted for inflation, in his opinion, he thinks it would be about 6.5 to 6.7 million exemption per person on the federal level. So that's what I believe. I will defer to his opinion about that, because he has a national practice, and I think would be a good opinion.
Okay, thank you. Next question. With a crummy trust, can a beneficiary waive their right of withdrawal? Is this done every year?
Yes, thank you for that question. The answer is yes. They are going to, we'll try to be humorous about it. They're not going to withdraw because that would not be the right thing to do when mother or father or grandfather or grandmother is making that gift. But they do have the right to take it. They have the real and absolute present right to take that. But the idea is that they are not going to take it, and they do have the right to waive it. And that's in essence what they're doing when they receive the crummy notice, which is the notice letter that it must be sent and it must be documented, because someday in the future we're going to have a stronger, more aggressive IRS, and we are going to want to document those things, but they can waive it by simply not taking it.
Okay. Next question. Good question. If we already have an estate plan done by Elville that is 8 years old, should we get an estate planning questionnaire to complete before setting up an appointment to review the plan?
Thank you for that. The answer is probably no. Thank you for asking. We probably have your current or your older questionnaire if you completed one. So the only thing that we would need is updated assets. So 8 years goes by, probably assets have changed, or assets have changed in value. So we just want to revisit an asset spreadsheet. We want to revisit statements and really see what your assets are, but you don't need to fill out a new questionnaire.
Okay. And in response to your thoughts about the exemptions, he says, thank you. I've heard 6.8 million. So that number sounds congruent to the amount and are getting closer to that concluding number. So thank you very much.
You're welcome.
Okay, so any final questions, please go ahead and get them in. I'll be sending out a follow-up email as I always do, as many of you know, and hope you get something out of that. The video, slides again, if you are interested in a consultation with Steve, we have a very efficient and easy process to get that done through his assistant, Barbara, who's wonderful. And I'll give you her contact information as well as mine, as always. As far as our webinar series goes, September 1st, we'll be back talking about estate planning and elder law essentials with Steve. We'll be welcoming back Kelly Nelson with Maryland Able, talking about Maryland Able accounts and how they benefit your loved one with special needs on September 12th at 10 o'clock. And then for our advisors, we have our advisors forum. It's back at 1 o'clock on September 13th. If you're an advisor and you didn't receive our initial advisors forum invitation, please let me know. I'll be sure you get one. And then lastly, on September 20th, we have an in-person presentation at the Howard County Library System Central Branch right at the Columbia Mall. And we'll be talking about Medicare, which plan is right for you. And we'll be welcoming our friend, longtime friend of the firm and advisor, Donald Oates, who'll be talking about Medicare. And I'll be there as well. Howard County Library is always a great friend of the firm as well, and a supporter of our educational events. Hope to see you there. And well, a couple more here. There is a recording available. We'll be sending that out. There's one of the questions. And the question is a follow-up to the questionnaire question. If we know our assets are well below the 5 million for Maryland, is there any need to provide an updated assets spreadsheet?
Well, thank you for that question. The answer, my gut reaction would be yes, because remember the updated spreadsheet, or the creating that, making sure that that spreadsheet is updated is really about making sure all assets are aligned properly, and making sure that our trusted fiduciaries, our future trustees, if it's a spreadsheet that we have, they are going to have access to that spreadsheet, and they have an accurate assessment, of what you still have. So I would say, generally speaking, it's a good idea to update the spreadsheet, especially after 8 years. That's been my experience.
Okay, very good. Looks like we don't have any more questions. Also, for our advisors, if you would like continuing education credits for today, be sure to send me your ID number if applicable, and I'll be sending out certificates and submitting your CE hours for approval tomorrow morning. Everyone have a great day, and thank you for being part of our Elville webinar series. We'll see you again soon. Have a great day.